So till now we have discussed that when we talk about breach of contract means that whatever is being promised to perform under the contract, it has not been performed, or something is being done which shows that the parties are not going to perform whatever is being promised. So as per the rules or law, Indian Contract Act, it is said that contract is enforceable by law, there is legal obligation, parties are bound to perform, and if they do not perform, then in that particular situation the other party has the right to go to court of law for the non-performance. So in this situation, breach of contract means non-performance. So in the case where there is non-performance, as per the legal law, the party has right to demand the performance or get compensation for the non-performance. When we talk about demand the performance, so as per the law, it is a legal obligation, and if it is a legal obligation, so you are bound to perform. So if the other party has refused to perform the contract, you can always go to court of law and can demand the performance. And when we talk about compensation for non-performance, so compensation for non-performance can be in terms of claim for damages or compensation in the other form. And if we talk about the meaning of breach of contract can be actual breach of contract or can be anticipatory breach of contract. When we talk about actual breach of contract, so actual breach of contract can be that the other person has at the time of performance specifically refused to perform, expressly declared that he is not going to perform, or he has not performed whenever the particular performance is due. So that is known as actual breach of contract. So जब भी actual breach of contract होगा, the other party has right to go to court of law to get the compensation, either in terms of performance or in terms of the damages or the other claims. But there is no weight or other action is required. So whenever the actual breach is being committed, the other party has automatically got the right as per the rules of the Indian Contract Act. When there is anticipatory breach, so anticipatory breach means that there is likely to be non-performance whenever the performance will become due. So it is not due at present, but some party has done something which is in contradiction of the performance of the contract. For example, A has promised to marry B on a particular date, but before that date, A has married C. So it means that there is going to be the anticipatory breach, the contradiction is going to be there, because if the particular person is, as per the Marriage Act, is allowed to marry only one person, so in that case the contradiction is there. So as per that law, the anticipatory breach is being committed. Or there can be a situation that instead of marrying the other party, the other person has just got engaged with the other party. So there can be some game or something like that. So in case of anticipatory breach, there can be express renunciation or implied renunciation. So it means that express renunciation, that the other person has beforehand declared that he is not going to perform. But in case of implied, he has done something which is in contradiction, that the performance is not going to happen. So in the case of anticipatory breach, the party has the two options, that they can wait for the actual date of performance and then they can file a case against the other party, or before the date, whenever the implied renunciation or express renunciation has happened, they can treat the contract as terminated and they can file the suit there and then only. So these two options are available in case of anticipatory breach of contract, right? Then we talk about the meaning of damage. So damage generally is considered as the difference price between the market price and the contract price on the date of committing of breach, whenever the non-performance or whenever the other person have come to know that no performance is going to happen in this contract and he is going to procure the goods from the market, or he is required to get the things from the other party. So in that case, if it is with respect to commodities and such, So generally the market price of the goods and the contract price difference is considered as the amount of damage. Otherwise, if we talk about the different types of damages, so there can be ordinary damages, there can be special damages, or there can be nominal damages. It's not nominated, it is nominal damages. And also there can be the exemplary or vindictive damages can be there. So these there are the different rules. We just have to understand that which type of damages are there. Then in continuation, if we talk about the different cost, different concepts, so in that case we the different concepts can be कि damages आपके damages का amount क्या होता है, और how it is different from the penalty, या damages को assess कैसे करते हैं, whether cost of decree would be part of the damages. So if yes, because filing the case or filing suit in the court of law involves certain cost, and if one party has not committed the breach of contract, the party was ready to perform and he has to go to court of law because breach is committed by the other party, then cost of decree will also become the part of the damages. And if we talk about the different kind of remedies for breach of contract, so there are suit for damages, suit for recession, suit upon quantum merit, specific performance, and suit for injunction as well. So now let's discuss this, that when we talk about the recession of contract is setting aside of contract, right? So when the party has set aside the contract, so in that case the other party has also have the right to set aside the contract. So in this particular situation where one party has refused to perform, the other party can resign the contract and he is absolved from all his legal obligations under the contract. So it means that whenever we are talking about the discharge of contract, so in that case, in case of breach of contract, the other party will be discharged from his legal obligation. But in that case, to be free from the legal obligation, the contract is to be set aside, because the one party has committed the breach of contract. So it is in that case you have the right to go to court of law, but also you have the right to set aside the contract and to keep yourself free from the legal obligations under the contract. Now when we talk about the suit for damages, so suit for damages are generally in terms of monetary compensation. So when we talk about the monetary compensation, already discussed that this particular monetary compensation can be in terms of the ordinary damages, nominal damages, special damages, etc. So when we talk about the ordinary damages, so in it generally these damages are available, and these are but this should arise directly from the breach of the contract. There should not be any remote cause or distance cause for the same. So if there is directly because of the reason of the breach, if some loss has been suffered by the party, so that loss is to be compensated by the party who has committed the breach of contract. So in that particular situation, this loss is going to be compensated and will be known as the ordinary damage. And generally the damage is between the difference between the contract price and market price of such goods on the date of the breach. So in this case, if there is any kind of remote or indirect loss or damage, you cannot claim the damages under the contract as the remedy for breach of contract. Then there comes the case of special damages. Now, when we talk about the special damages, so special damages cannot be claimed as a matter of right. This can be claimed only when it has been communicated. If these are not being communicated, these are not in the knowledge of the other party, then the special damages cannot be claimed as a matter of right. For example, A has entered into a contract with B to supply certain goods by Sunday evening, right? B got delayed and B could not, supply. and A had already got a particular, you can say, the transport booked where the other consignment was going, and for B's goods, he had to incur another 10,000 rupees for the transport or for the penalty that the particular transport got delayed. But this 10,000 rupees loss or penalty that due to the non-performance, this is going to be, suffered by A has never been communicated to B. So B cannot claim this 10,000 rupees. Else, if it would have been communicated to B that the goods needs to be delivered by Sunday evening in all circumstances as the other consignment is going, else I'll have to pay 10,000 rupees extra for the transportation of the goods, which will be borne by you. Then in that particular situation, he can claim this 10,000 rupees from B in case there is non-performance by B as per the contract requirement. So special damages are those damages which cannot be claimed as a matter of right. These can be claimed only if the special circumstances which would result in a special loss in case of breach of contract and where are brought to the notice of the other party. So they are not recoverable unless the special circumstances were brought to the knowledge of the party. So it is must that this must have been communicated. Otherwise, this particular loss cannot be claimed as a matter of right. Then, in this particular situation, if we talk about case law that is about given under section 73, so this case law is by Hadley versus Bandel. In this particular case, what happened that there was hypothetical as a fact of the case or storyline that there was a particular, factory manufacturing unit was there. So in this, the work was going on, and one particular, work was going on, and then one particular part of machinery broke down, due to which all the manufacturing or all the things were stopped. And B has been asked to send the particular item or particular part for repair. And due to some miscommunication or something, that particular repaired part has been, got some delayed or it has not been returned as quickly as possible. So A has filed a case against B that whenever the particular shutdown was there and whatever loss of profit has been suffered, this has been, you know, filed, the case has been filed against B that you got the particular part delayed. So whatever loss of profit has been suffered by the unit, you are going to pay that. So court held that whenever the B has been assigned the duty to send the particular part for repair, though urgency was there, but it has never been communicated that whatever loss of profit would be there, that is going to be suffered by B. So this special damage or this special loss cannot be claimed as a matter of right until unless the circumstances were brought to the knowledge of the party. So this point generally come as an independent part or otherwise. So we have to be little careful. So here we can talk about as per section 73, this rule is being given. Then when we talk about the vindictive or exemplary damages, so when we started the particular contract act, we say that we are dealing with the civil law, and civil law talks about the relationships that can be the business or the personal relationships or otherwise. So in case of your business law paper, We are talking about the rules and regulations related to the business, and even certain aspects are covered, certain acts are covered. So it does not comprise all laws related to the business. And with respect to the personal, there is a separate stream of the law. So when we talk about the vindictive or exemplary damages, so in case of civil law, there is no place with respect to the punishment, imprisonment, etc. So, in this particular situation, vindictive or exemplary damages are not generally awarded as a matter of right, but there are certain exceptions that if there is a promise in case of to marry someone and there is a breach of that, then there can be certain, compensation is demanded in terms of because of the mental suffering of that particular person. And where, as per the banking law, if there is a wrongful dishonor of the check by bank, in those circumstances the particular party can file a case with respect to the claim of damages because of the wrongful dishonor. There is a loss of business, loss of damage, so there can be even the reputation of the particular person might be at stake. So in that case, vindictive damage, certain kind of punishment can be demanded. Otherwise, the as a rule, there is no place of vindictive or exemplary damages in the contract act, but the court has a right to award these kind of compensation to the other party as well. Then in continuation, we talk about the nominal damages. So nominal damages means just to make the other person realize that he has not performed the contract will be known as the nominal damage. For example, if you have got the library book issued and there is a fine of rupees 5 per day. So I think if you make the book delayed by 10 days, so rupees 50 might not be that much valuable for you. But this nominal damage is being imposed to make the other person realize that this particular discipline is to be followed. Whatever is being promised is to be, fulfilled. So if the book is to be returned on by a particular date, so it is to be returned. Otherwise, this penalty or this nominal damage you are required to pay. So this is similar way. If any person has not performed the contract, so this can be imposed as a fine, that so that the other person realize that he has not performed the contract. Then these damage for loss of reputation is only in case of the bank, and relation damages with respect to the inconvenience and discomfort. There is no as such rule, or we cannot recover any damage with respect to certain physical inconvenience or discomfort. So this is not covered under the particular contract. Now, when we talk about the mitigation of damages, so it means that whenever we are trying certain kind of loss, so the other party has also put best of the effort to minimize the loss. So in that case, if the other person has not put that effort, so probably the person cannot claim those damages as such. And if we talk about the difficulty of assessment, so difficulty of assessment, if it is difficult to find out the amount of the damages, etc., then whatever court is going to decide and the circumstances of the case will be there. So these will be considered as the final verdict and the final law. Cost of decree, we have already discussed that the cost of filing of suit or incurring any kind of expenditure for that, that is considered as if you won the case, then it will be considered as a part of the damages, it will be added. Along with this, we have to understand that any kind of remote cause, indirect cause does not affect the case, or if there is no loss directly out of the contract, so you cannot claim the damages as a matter of right. And if there are damages agreed upon in advance in case of breach of contract, so as per the terms of the contract, you cannot file, put a condition that the other person does not have a right to go to court of law. But if there are certain kind of fine, certain kind of penalty, etc., is being decided by the parties in advance, so that is going to be applicable. and even we can go to the third party. So arbitration can be used in case that the decision given by the third party would be amount of the damages. All these things would apply. Then we have to discuss about the liquidated damages and penalty. So damages are as per the we can say pre-estimate of damages. So liquidated damages can be in form of that beforehand we have decided that the damages are fixed and the penalty is determined. So whatever loss is going to happen, that loss is estimated in advance. So that is known as the considered as the liquidated damage. But we talk about the penalty. So penalty is not related to the amount of loss. For example, we have discussed about the fine. So it is not related to the loss. But if there is liquidated damage can be, for example, you are required to take care of the book. That book should not be torn or damaged as such. Otherwise, you have to pay the price of the book, or you have to replace that particular book from the market. So this price of the book in case of damage is considered as the liquidated damage, which is the pre-estimation or estimation in advance with respect to the loss of the good in case of contract. And when we talk about the penalty, so penalty is in kind of fine for the non-performance which is decided by the party. So this can be ensuring the discipline, ensuring the performance of the contract. So for example, if you need to fill up the examination form, so these examination form need to be filled by a particular date, or if you there is certain kind of communication or certain kind of application is there, then you have to apply, or certain kind of payment of fee is there. So that performance is expected with respect to by imposing the penalty. Otherwise, if we talk about the liquidated damages, so in case of breach of contract, whatever loss is decided in advance will be considered as the we can say the probable loss. So I think the remaining concepts with respect to the we talk about the how the interest or other kind of things can be considered as the compensation in case of breach of contract, quantum merit, etc. We can carry on in the next class. So let's discuss if any queries you people have in this particular topic, and then we'll discuss all these remaining topic in the next class.